Here. All right, can we have the Pledge of Allegiance? And then we'll, left your stuff, we'll proceed.
Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
That's all right, you're good. I got it, I'll put it up for you. See. Could we get a motion on the minutes?
Brother Chairman, I make a motion to accept the minutes from the last meeting.
A second.
This is to accept this approval of the minutes from 8/14/24, Commissioner Fernandez.
Yes.
Commissioner Jackson.
Yes,
Commissioner Bergy.
Abstain.
wasn't here.
Commissioner Rodan.
Yes.
Commissioner Jackson. Commissioner Tracey.
Yes. All right, we're going to suspend the rules for a short time so we can hear from Enrique. I'm sorry, you're, it's Sringa. I should have had you guys help me out with the pronunciation. I apologize. From Post to educate us a little. Thank you. You can take over, sir, and we'll get out of your way. We'll switch positions. Get this stuff all the way. Where we can see everything.
You moved the PowerPoint all the way. So make sure you go backwards.
Oh,
The
gosh.
way you were carrying something.
Oh, you know what? That sounds like me. All right, let's see.
Just from the beginning, from the beginning.
Yeah. Just trying to get my mouse over there. No. Sorry. I'm having a hard time seeing that. Yeah, it's just at the, just need to, okay, and then.
There we go.
Oh, I don't know, maybe. We'll see. We'll find out. There's still a lot of light that's gonna come through.
good?
the window, though.
Okay, thank you. Good evening, everyone. My name is Enrique Zuniga. I am the Executive Director of the Post Commission, the Peace Officer Standards and Training Commission. It's a pleasure to be here with you. With me is our Communications Director, Cindy Campbell, who can help me navigate through a presentation that we have here for you and can answer any questions you may have. Please interrupt me as I go through the presentation. This is about 41 slides, but I want to make sure there's, of course, we address any questions you may have because this is really for your benefit, and we're happy to be here. Just by way of agenda, I'm going to be giving you an overview of the certification process. I'll touch briefly on the School Resource Officer certification. There's some exceptions to certifications, which again, we'll get into some nomenclature. We'll get into what's probably a lot more relevant to your mission, and that begins with number 5 in the complaint and incident reporting that is due to Post. I'm sure, I understand from your charter, you also review. We'll get into some details into preliminary inquiries, which is the term that the statute has for the investigations that Post conducts. And we'll also touch base on some suspensions, which is another mechanism that we have to impart discipline while we're doing an investigation. We'll, of course, we'll just touch briefly also on what's coming down the pike for Post that may be of relevance to you as well. So I'll have a brief overview of Chapter 253 of the Acts of 2011, the law that created Post. It's also known as police reform, was signed in the last day of 2020. That was the year of, the unfortunate death of in Minnesota in May of that gave way to a lot of police reform throughout the different states. In our case, in the case of Massachusetts, it created a 9-member independent majority civilian commission that I report to. This is a 9-member part-time commissioners. They're selected from different backgrounds according to the legislation, and it has the authority to create a mandatory certification process for all officers in the state, approximately 21,000 officers, as well as a process to decertify, suspend, or discipline officers throughout all, municipal and state police departments in the event of certain misconduct. We also work closely with the MPTC, the Municipal Police Training Committee, that imparts and delivers a lot of the training. There's other approved academies that work in conjunction with the MPTC, but we approve the training programs that they deliver, and we have the remedies for lack of compliance with those training programs as well. So we work very closely with the MPTC, and that's all outlined in the legislation. Just a couple of broad themes of the legislation. It's, of course, to ensure accountability, improve standards for policing, enhance trust between police and the communities that they serve. We recognize that the sacrifice and the commitment of officers is greatly appreciated, and the vast majority of them do their jobs well. We'll get into some numbers in a little bit, which are very good and indicative of what we are dealing with. But the reality is that when some engage in some form of misconduct or excessive force, there is, of course, significant erosion to the trust of the community, and nobody really wants that, including everybody within the police departments. Other items or themes of the legislation: agencies and officers can benefit from consistent training. A lot of what we are seeing is, which might not be surprising, different levels of imparting discipline, because there's very many agencies of all sizes throughout the state. We have about 433 agencies. There's very many that are very small, just 9 to 5, 3-5 person department. We have agencies within hospitals, some universities, and they tend to be smaller departments, but nonetheless they still have police powers, and they need to be certified by post because they come within the scope. So we also have a lot in terms of collecting information and disseminating some of that information, which includes some aggregate reporting, and we believe, of course, the mandate in the legislation assumes, and I think it's a good assumption, that the public will benefit from all of that information. We take steps to help officers be more effective. It's not about a punitive approach. We've started to develop and think about ways to recertify officers along the lines of health, physical and psychological health, that would benefit the system as a whole. And I can speak into some of those details later, but it's not just being punitive to individuals. That is a big component, but it's also about enhancing the standards for everybody. And again, collectively, we believe all of these steps, including on some of the collaborations that we have with partner agencies like the MPTC and EOPS, can help us help everybody better the police throughout the state. Just a couple of highlights of other things from the legislation. It restricted officers' use of force. It specifically codified in some cases, techniques that were no longer in use, but now they're against the law, including chokeholds and restricting air passage when imparting force. There is now a very clear duty to intervene where improper force is being applied by others. It's also a duty to report to the agency and to post of those cases when the officer believes that there's improper use of force. There's restriction in the use of facial recognition technology. That wasn't the case before post, but again, some of these things have now been codified into law. It limits the exchange of information between officers and schools regarding students. There's a whole host of regulations and legal scheme under the School Resource Officer scheme. There is a ban on racial profiling. We're supposed to work with the Attorney General to detect trends that might get to the notion of racial profiling. There's again certain other provisions like sexual relations with those in custody, restrictions of the use of no-knock warrants, and other things as well that may have been already not in practice, but they're now codified into law. Other things about Post and the Municipal Police Training Committee work very closely to establish certification requirements. We're charged with developing the certification standards and certifying officers. We also have to certify agencies. We have not done that yet. That's a very broad, large topic. We are only going to be able to do it incrementally. Again, more on that later. But we're, of course, charged with receiving, investigating, and adjudicating complaints. Many of them come via the agency because they come to the agency first. In cases like you may see those complaints as well. There's other bodies like you. There's one in Boston, the Office of Police Accountability. Has a similar charter to yours. They receive complaints when in those cases, when the police department knows of a complaint that is not minor, and I'm going to get into more details on that, that complaint is required to be submitted to Post within 2 business days. Again, there needs to be some ascertainment of credibility. They need to know, enough information to be able to act on it. But suffice to say that the complaint is due to Post, or the incident, it could be an internal incident that is due to Post very soon after the department receives that. Post can receive complaints directly from the public, and we may investigate them, or we can refer them to the agency to have the agency conduct the internal affairs investigation. We can, of course, refer to the Attorney General. We must refer to the Attorney General or the U.S. Attorney or the District Attorney when we suspect that there is criminal behavior. We are not a criminal prosecution agency. We are also, lastly, required to maintain a public database with the officer disciplinary records and their certification status. And a lot of that information is in our website. We continue to make enhancements to those databases. I'll invite you to check out our website, in the near future. Absolutely. Yep.
So the last part about you keep a database, right?
Yeah.
Now, Springfield has a large department, has Board of Police Commissioner stuff that is overlooking their officers. Might have a lot of small complaints where you get a small town, 4 or 5 officers, even 15 or 20 officers. Everything's internal with the department itself. They don't necessarily get that amount of complaints that would come up to Post. So is that kind of being a little bit like some of the larger city departments than in the small towns, I mean, is there a balance there to try to?
Well, the statute and the regulations make an exception for minor matters. When there is matters that have to do with basic work rule violations like inattention to detail, grooming, or discourtesy are not required to be submitted to post. So those should not be in the database. Initially, when we did this big data collection, some agencies decided just to put everything, and then later came out and said, well, actually that's a minor matter, and can you take it off? And in most instances we did. Now, there continues to be a lot of complaints that flow through our database, and we'll continue to update them and aggregate them. 3 years after an officer retires, their disciplinary history comes off. So the database is meant to be sort of fresh and current. Now, let me say something about your question about the disparity, if you will. There's internal complaints, internal incidents for which people get disciplined, and that happens throughout, in every, save the minor matters, small agencies submit complaints to us. Perhaps not at the same cadence, in the same amount as a large department, only by virtue of the size. But it is true that certain departments, like Springfield, Boston, the state police, they have many more interactions with the public that may give occasion to a complaint. And it's fair to say that perhaps even certain assignments may give merit to more complaints. If you are interacting with the public all the time, there may be again more complaints submitted. Now, let me clarify a couple of things. We only publish sustained complaints. We don't publish unsustained, exonerated, or unsubstantiated complaints. We have seen, because we get a lot of these directly submitted to us, unfortunately, a large number of complaints that come from a small group of people that are at times dealing with a number of issues unrelated to policing. They end up, interacting with police, but it's not. It's perhaps an emotional issue or a mental health issue or what have you. Now everybody gets an assumption of credibility when they submit a complaint, but there's very many that are not sustained or exonerated, and those are not part of the public database. We do collect them. They are due to us when the department submits them. They can later say, we won't publish them until the investigation is completed, and if the officer was exonerated or the complaint was unfounded or not sustained, that won't be published. Now, advocates and certain other stakeholders say, why not? There's a case to be made that even unsustained complaints should be made part of public databases. We made the decision after consultation and promulgation of regulations that publishing a lot of unsustained complaints could result in depolicing, people just deciding to be less proactive, as a result of that. Again, there's viewpoints that disagree with that notion. What we will and intend to do is publish unsustained complaints in the aggregate, perhaps by agency or perhaps by rank, and then the public could make a comparison that perhaps similar communities, let's say, Chicopee and Holyoke, similar size, similar demographics. If there's big differences, there may be something worth of further inquiry, for example. We have not done that yet, but our intention is to aggregate enough data to then report in the aggregate unsustained complaints. Okay, so we were on certification. Certification is required for the appointment an employment of an officer and to conduct police duties and functions. So in other words, for sworn officers. We don't certify or get information about civilian dispatchers, for example, that are also employees of police departments. If an officer retires but continues to do details, they need to be certified by post as well, or they need to continue to be certified by post. We certified, for example, deputy sheriffs because they do conduct police duties and functions. The sheriff departments also have a lot of correctional officers. They don't come under post because they are not conducting police duties and functions. Everybody who was active on July 1 of 2021 was granted a certification automatically by the statute, by the law, and they had, according to their last name, expiration of those certifications that were going to be renewed, every year subsequently. So let's go to what that timeline was. For officers with last names A through H, they had to be recertified on July 1 of 2022. Those with last names I through P on 2023, and we just finished the last round of certification officers with last name Q through Z on July 1 of 2024. So we now have everybody that's active in the state that comes within post, approximately just shy of 21,000 officers certified in some capacity by post. Do you want to go to the numbers? Yes. Yeah. So these are the numbers behind me. Just to give you an idea, there's 20,104 as of September 1st. 20,104 people that are certified, 403 conditionally certified. That is functionally the same as being certified, except with the requirement to meet certain conditions that are not dispositive. There are 298 individuals that are not certified. There's 303 that are not certified because they are on leave and they cannot meet the requirements for certification. In some of those cases, it may be an administrative leave. Excuse me, I'll get that later. And that means that there may be an investigation going on or a criminal procedure going on, and that needs to be resolved before they can come back and either be certified by post or disciplined by post. We have 55 suspended individuals. We must suspend an individual when they are charged or with a felony or arrested with a felony or convicted. We have a number of those as well. There are instances, these are very few instances in which the commission may suspend an individual because they are a harm to the public, and their matter may still be pending, and that's the notion of a suspension. We have the ability to administratively suspend individuals if they do not complete their in-service training, or if they fail to report to post certain reporting requirements. Those 4 that you see there are only because they have not complied with certain in-service training requirements. We have 27 individuals that have been decertified. Decertification is the end of the road. It's really the career-ending path for people. When somebody is decertified, they can no longer work as a law enforcement officer in any capacity, not in a consulting capacity, and they're entered into the National Decertification Index, which is consulted by most of the states around the country. So that effectively means that that person is prohibited from coming back to law enforcement altogether. And there are, because we are now in the final round of certification, there are some certifications that are beginning to expire where people are not being renewed, and we started to have this category of just expired certifications. Certifications are prospective, somebody may be certified for the next 3 years, and then anything can happen between those 3 years. They could retire, they could be injured, they could be decertified, etc. But the certification cycle happens every 3 years, and so on. So I'll say very briefly, I don't know if Springfield has an MOU with the superintendent of schools and have school resource officers. Chapter 6E requires that the school resource officer meet certain additional criteria to be certified as an SRO for post. So prior to being an SRO, all individuals need to be first certified by post, and then they get an SRO certification. So there's essentially 2 certifications. The SRO certification is good for 1 year, and is really tied to the SRO training and certain other representations that they're required to do to post in their capacity as an SRO. We began certifying school resource officers in October of 2023, and to date, there are approximately 464 individuals who have completed the SRO training and have obtained the SRO certification. Any questions so far, or is this a good cadence? Absolutely. Actually, you already did, but we already sent it to you guys. But we can of course send more copies. Yep. I'll just mention a couple of exceptions on certification before we get to the disciplinary process. There's a conditional certification. In certain cases, post will issue conditional certifications. This enables the police officer or the officer to continue to have those powers with the condition that they meet certain requirements at a later time. The most typical reason somebody may be certified conditionally are individuals that were reserve officers. They had never attended basic training. This didn't happen in large cities. This happened more in smaller towns. They never went to academy training, and they were referred to as seasonals or reserve officers. They would use them in the summer in certain communities, and they had never gone through basic training. So because of the passage of the legislation, all of those individuals had to be certified by post and have to have gone to basic training, and the compromise, if you will, was that they attend the Bridge Academy so long as they also complete 2,400 hours in on-the-job training by January 1st of 2027. So there's a number of individuals who went to the Bridge Academy instead of the 800-hour basic training academy that normally happens these days. The Bridge Academy was about a 200 plus hour of training, and again, those individuals remain conditionally certified until they complete those 2,400 hours of job training, of job experience. There's also in-service training. Everybody has to have their annual in-service training, and when they have not met in the in-service training requirements by September 30th, they could be deemed conditionally certified until they meet that requirement. There's also a requirement to be current on their CPR certificate, and if they have not met those at the end of June 30th, the round for certification, they have until September 30th to do that. Now, when an officer does not meet the requirements for certification, they will be categorized as not certified. That means they cannot conduct police duties and functions. We've had a number of those cases. In the most common instance is an instance in which a chief declined to attest to the good moral character of an individual for us to review. That happened in some instances. If our review sides with the chief that there's enough past misconduct in the individual that would render that individual not of good moral character, then we decline their certification and note them as such. Now, when somebody is not certified, there's still recourse by that individual, which is different from what I mentioned earlier. Somebody who is decertified, that means they are expelled, if you will, from police law enforcement. There's possible actions following a decision to deny granting full certification. We're mostly done with these instances because we have gone through all those recertification processes. But if a chief or head of agency declined to attest to the good moral character of an individual, they had to send that information and reasons to the officer. The officer had 21 days to review that and petition on a review before me, the executive director. I could take in more information, have a meeting with the officer or other character witnesses, if you will. That person had an opportunity for a hearing, and if I deemed that person not to be worthy of certification, that person could still then request a hearing in front of the commission or a hearing officer to be considered for a second time. Once it comes before the commission or the hearing officer, the commission could vacate a prior decision, in other words, reverse what they did, or they could validate that decision. And in some instances, the officer could reapply for certification, as if they were applying de novo. That happened very rarely, but that was still a possibility.
Excuse me. Who's in the responsibility of the hearing officer? Who's there supervise the hearing officer?
Yes. No, so the hearing officers are appointed by the chair of the commission. I report to the 9-member body, which is the post commission. That's chaired by an individual, a retired judge. She appoints the hearing officers. They essentially report to her, but they only from an assignment perspective. She's appointed retired judges from Superior Court who are very familiar with Chapter 30A, civil due process, and that has been working out very well for us. Now, the hearing officer only is a fact finder. They have a hearing, they have a fact finding mission, they issue a draft decision that is ultimately reviewed by the commission and accepted or not. The ultimate deciding body is the post commission. They generally take their decisions in executive session, given that there's a number of exceptions that apply. They deal with the potential character of certain individuals, and that's an exception to the open meeting law rather. And so, but there's typically we meet monthly. The commission meets monthly, and there's typically a public session and a rather lengthy at times executive session that reviews each of the individual cases. Yeah, 15 minutes, okay. Thank you. So we have, let me get into the complaints and incident reports. The information that it's due to post is all incidents that are non-minor matters, internal or external, whether they come from a complainant or whether it comes from a supervisor or whomever within the department. The 2 business days is a real challenge for everybody. We've had a number of questions around this topic. What about when there is not enough information? For example, where there's a complaint about somebody, but we don't know who that is. We've issued guidance in our website, and we've distributed to communities. There could be a reasonable amount of time to spend before ascertaining the nature of the complaint, so long as it's not unreasonably more than 2 business days. But the statute implies that complaints need to, and reports need to be submitted to post very quickly. We had to build a portal that we are now interacting with agencies to make sure that we could, comply with this very tight requirement. Again, there's guidance in our website. There's certain reports that can be excluded, minor matters when it comes to unprofessional conduct, but certain cases, when it comes to excessive force, officer-involved shooting, or events that resulted in serious bodily injury or death, there's no exception. There's no minor matters. All of those cases, or bias, when there's an allegation of bias, excessive force, or any actions that resulted in bodily injury or death, including officer-involved shootings, they must be submitted to post within 2 business days. We went through these already, allegations of bias, use of force, bodily injury or death, all must be submitted to post. There's sections 10, 14, and 15 of Chapter 6E, which is the legislation that created post, describes a lot of incidents that constitute prohibited conduct, submitting false timesheets, a number of things. All of those incidents must be reported to post as well. Now, complaints that allege unprofessionalism also need to be submitted to post, again, with the exception of minor matters like discourtesy, grooming violations, and tardiness, etc. Now, there are certain timeframes that are not widely understood by some of the police departments after that initial submission. The LEA, the law enforcement agency, is required to start, it's not in this slide, but it's required to start an internal affairs investigation within 14 days of that initial submission, and is required to complete that internal affairs investigation within 90 days of that incident. In some cases, that is not possible, but they must request an extension of post about those 90 days. And for a variety of reasons, we, of course, grant those extensions, but we track those dates in our portal. There's aging reports, etc., and we have begun to communicate with agencies to make sure that these requirements are adhered to. After the IA is completed, it's immediately supposed to be entered into our portal, and then subsequently, when the discipline is imparted, that information also needs to be submitted to us. We recognize that there may be some instances in which the IA is completed and the discipline comes in at the same time. There are other instances in which that comes at very different times. That's fine. We recognize that happens, and our portal allows for that. There's instances in which the discipline is submitted and then later reversed because it's appealed or arbitrated, etc. We recognize that happens, and we also accept all of that information that comes back to us later as necessary. Now, this is very key, and it's underlined here. When we ask that when there's a discipline or an IA investigation completed, if the head of the agency recommends that we take action, including decertification, then the statute requires that the Post Commission initiate a preliminary inquiry. And those are the cases that we tend to focus on. When there's an affirmative recommendation by the head of the agency that Post take action, including decertification, we will open a preliminary inquiry. Any questions or comments on that?
So IIA will make a report. If they feel it has to be moved to post, they will submit it directly to you guys?
If they feel that the IA needs to be submitted to us? Yeah. Now remember, there was the incident within the 2 business days. So in theory, we should have something already that is, if it's not minor, right? Now it's possible that you conduct, the agency conducts an internal affairs investigation and begins thinking it's minor and then finds out that it's not minor. And that's fine, they should be submitted to us. But we really should have two submissions by the time an internal affairs investigation comes in. The first one and then the completion of the IA. By the way, that doesn't always happen, which is why I'm giving you this long response. We sometimes get the IA, for the first time. Here's what happens, and well, remember, you were required to submit it, beforehand. Okay, so this is just a look of a portion of our website where the public can go and submit complaints directly to us. They can do so anonymously. As you can imagine, following up on anonymous complaints is a little bit more difficult, but we do accept them anonymously. We may take steps to investigate on our own to ascertain credibility, and we may refer them to the agency who must investigate them if they get that referral. We also have other helpful resources in our website. There's a YouTube channel. We invite you to look at it. We'll send you links to our rebranded website that has seen a lot of additional traffic, which is great. I'm going to touch base on preliminary inquiries real quick. As I mentioned, the PI, or preliminary inquiry, is a term in the statute that refers to the investigatory process that Post undertakes. All proceedings and records relating to a preliminary inquiry are confidential, are as per the statute, including records as to whether we believe there should be a preliminary inquiry. And that's also in the statute. Of course, we may turn over to the Attorney General, or the U.S. Attorney, or the District Attorney any information we believe may merit criminal proceedings. Now, when we initiate, when the Division of Standards initiates a preliminary inquiry or ascertains that there's a complaint and there's sufficient credible evidence that an officer committed felony, misdemeanor, etc., or engaged in any kind of prohibited conduct, the Division of Standards, which is our prosecutorial body, will come to the Post Commission and ask for approval to initiate a preliminary inquiry. That also happens in executive session, and as I mentioned earlier, if the Commission, in other words, the staff, receives an affirmative recommendation by the head of the agency of disciplinary action, which may involve retraining, by the way, it doesn't have to be just decertification, we will initiate a preliminary inquiry to conduct our process. Now, as I mentioned, the proceedings are confidential. We request those approvals in executive session. The head of the agency, the officer, and the head of the bargaining unit are notified about these proceedings. That's also in statute within 30 days. By the way, it's sometimes those parties go to the press and say, here's what's going on. The press calls us and say, can you confirm? And we say, those proceedings are confidential and we cannot comment. But nonetheless, we're required to submit to notify those parties, and we have no control over whether they remain confidential after they are notified or not. When the Commission, by the way, may suspend the certification of an officer as part of the preliminary inquiry, there are certain key provisions as to when that happens, and may vote to initiate adjudicatory proceedings, which is a subsequent step once a preliminary inquiry is completed. The adjudicatory proceedings are no longer confidential. If we decide to start adjudicatory hearings, the Commission may, through a hearing officer, begin a hearing in order to do fact findings, impart discipline, order retraining, etc. Those hearings are presumed to be public. They, at the discretion of the hearing officer, may be closed in part or in full. if it's only to protect the privacy interest of third parties, for example. But again, they're presumed to be public. Those hearings, we've had some of them, and once the hearing officer closes the hearing, they issue a draft decision, and then they'll bring to the commission to approve the initial decision or the final decision. I'll mention something quickly on suspensions. We are still okay on time. 2 minutes. We have administrative suspensions. I'll mention this quickly. If the officer fails to complete in-service training, they may be administratively suspended. But I think notably here is that, once they complete the training requirements, that administrative suspension can be lifted fairly quickly. Now, I'll mention something else. An administrative suspension can be imposed for failure to report to post certain mandatory reports. We have not utilized that suspension yet. If we do, it may be an instance in which we see a trend of failure to submit to post continuously or more than an incidental matter. And if we do, we won't be, we won't have reservations about administratively suspending potentially a high-ranking officer if we detect that there are systemic lack of reporting to post. We don't have an indication that there's a lot of lack of compliance at this time, but again, this could be something that might happen in the future. Now, on mandatory suspensions, the Commission immediately has to suspend the certification of an officer who's arrested, charged, or indicted for a felony. That authority, because it's a requirement, it's mandatory, has been now delegated to me, so that as soon as we learn that somebody has fallen in this category, I will issue a suspension. The officer may request a hearing before a single commissioner prior to any suspension, including a mandatory suspension. And if the charges are dropped or reduced about a felony charge, the officer may require the lifting of that suspension before the commission.
Excuse me, under the suspension, are they paid suspension or non-paid?
We have no say into whether that's pay or not. We just say that if you're suspended, you cannot conduct police duties and functions. The statute is silent as to remedies or powers that the commission may have relative to that notion. It would probably fall under collective bargaining agreements or really the local jurisdiction as to whether that happens or not. Now, the commission may suspend an officer who is charged, indicted, or convicted for a misdemeanor. But again, we consider aggravating evidence relative to which misdemeanors relative to those suspensions. If the commission determines by a preponderance of evidence that the crime affects the fitness of the officer, then we will issue a suspension. Now, a couple of more slides on decertification. Being classified, as I mentioned, as not certified is different from being decertified. An officer may be decertified as a result of certain forms of misconduct, and after appropriate procedures taken by post, including the adjudicatory hearing, that process that I described. Decertified officers cannot work for the law enforcement agency, sheriff, the executive office of public safety in any capacity, as I mentioned before. Also, the names of decertified officers are placed in the National Decertification Index, which we participate in. Incidentally, we're one of, I think, 7 states that must submit to the National Decertification Index their decertifications. Many states do it voluntarily, by the way. I'll do it very quickly because I know I'm a little bit over time. I'll just mention some future matters. there's a lot of there's language in the statute that says that we should ascertain the physical and psychological fitness of officers on an ongoing basis. This is a big issue for the police world. It's something that throughout the country everybody's struggling with, how to maintain and keep both physical and psychological fitness. On veteran officers, they're widely accepted that everybody coming into the force must pass one physical test and a psychological test, but the ongoing wellness of officers is a big topic. However, the statute does assume, and we intend to tackle, the notion of how to continue to enhance and corroborate that the officer continues to have physical and psychological fitness to conduct their duties. We also have a future policy matter in the certification of agencies. The statute says that the Post Commission shall certify agencies according to 8 standards, and nothing much more. Unfortunately, the statute is silent as to what other standards we could apply. There's very many that we can think of that should apply for certifying agencies. This is something that will be a big lift for everybody, and we intend to do it incrementally, and will likely begin by meeting certain standards as minimum requirements, and go from there. Check out our new website. It's mapostcommission.gov. It's in our signatures as well. We have a lot of information there that's very relevant, including the status of officers, their certifications, some of the details of what I only highlighted here, more explanation on our disciplinary and adjudicatory process, and presentations like this that can be helpful for, of course, yourselves and the public. So let me pause there and see if there's any questions or additional comments. Yes, sir?
I just had a question about the disciplinary process. So have you had issues where an officer has received discipline at the municipal level, and then the municipality is barred from imposing any further discipline, and then Post comes in and attempts to impose further discipline on that officer? Have you had any problems with collective bargaining agreements in doing that?
There is not. We have not. We have seen only a couple of those instances, but our read of the statute is that we are not subject to any, our discipline is not subject to any discipline, any collective bargaining agreements. So it is possible that by collective bargaining rules, the suspension could only be 5 days or 30 days or reinstated, etc. We could still impart additional discipline if that's what the commission ultimately decides, which is where the recommendation about action by Post, by the head of the agency, is really an indicator for us, a big flag for us. If the agency head feels that they have no authority to impart more than 5 days, for example, but thinks that it merits more action, we of course will look at that and consider it and may take action. We're not required, but we might. What we're required to do is open up a preliminary inquiry, which we will do.
Your meetings, open session, could we see those when you have your post-commissions meetings?
Yes, we broadcast them, on our website. You can, everybody can sign in and just, not sign in, just click on the link and observe it. There's, you can sign up for alerts, which then will cause us to send you an automated email that there's an upcoming meeting or, there's an upcoming hearing. People can sign up for different things. When we issue written decisions, which is how we like to talk to the public mostly, and the press, here, read the decision. We also send notifications, so people like you and others can sign up for those alerts, and we're happy to put you in those distribution lists. Yes, sir?
When you say impose discipline, can you describe that, or you mean you suspend a certification? When you say you impose discipline, exactly what does that mean?
So the statute says that we can impose a discipline like retraining, and we've done that on a couple of occasions. That's an important aspect. We have suspended, the commission, not we, the commission has suspended the certification of an individual in a couple of cases for an extended period of time, 2 years in one case. And that means that the officer, again, cannot conduct police duties and functions. Whether the agency at the time then decides to pay them, not pay them, assign them to a desk duty, which can get tricky into conducting police, police, if you're investigating certain things, let's say, even on desk duty, you may be conducting police duties and functions, but certainly cannot arrest, cannot conduct warrantless searches or use force when your certification is suspended by post.
I have one other question.
Yes.
An officer involved shooting, you receive a report, what do you do with that?
Well, first aggregated in our database. We are required to report it to the legislature on an annual basis. We typically see, and there's many parties, including district attorneys in some cases, that look at whether there needs to be, a follow-up in many cases, and in those cases we'll defer to that decision. I can speak to, there is now a new, the legislation prohibited the shooting of a fleeing car. If somebody's fleeing on a car, shooting at them is now codified in law as prohibited. We had one instance in which we had to review a case like that. We may review it against prohibited conduct, but it may be that, for a variety of reasons, there's others that have that matter, like district attorneys, and we'll just wait to collect that information when it comes back to us and report it to the legislature.
I have one other comment.
Yes?
If my math is correct, out of the many officers that are certified, only 27 are decertified. That's 99.865%. What does that mean? Is that something to be proud of?
Yeah.
Better or worse? That's I'd bet on that any day.
Yeah. Well, it means a couple of things. We're just getting started, to be fair, but it really does mean that it's a very small group of people that will cause, the post to take action. I'll tell you another interesting, data. We have our disciplinary records that are on our website. They're very lengthy. There's about 4,000 records of individual officers. That represents 10% of the total population. So people with actual records still working and disciplined, maybe they were suspended, for 30 days or 5 days or what have you. Again, those are active officers. That's only 10%. There's what you will not see, for example, but it's important to remember, on the third suspension, perhaps people will exit the system, and they're no longer in our database after 3 years, and that's the nature of the population.
Thank you, because it's something to be proud of.
Yeah, there's very many people, as I mentioned in one of these bullets early on. There's very many people that have an unblemished record. They do their work. They do it honorably, and they don't like when other people that engage in misconduct, paint the rest of the department in a bad light, and that's what we're here to do, frankly.
One other question, I'll hold everybody up, but, so, we do all the discipline, so now we give an officer 10-day suspension, you're notified. We give another officer 60-day suspension, you're notified. And we terminate an officer, you're obviously notified.
Yes.
Now, is there certain steps where you would look at the case closer? I mean, let's say it's a 10-day suspension, you basically say, the heck with that, but if it's a 60-day, in other words, is there a set time when you look at the cases, certain?
Yeah, so we do exercise, let me put it this way, some discretion as to what our division of standards, exercises discretion. I don't think I'm revealing any secret sauce to say that our focus has been mostly in interactions with the public or something that affects the policing and fitness of somebody to be a police officer. If there are, for example, workplace-related, matters, we're likely to defer to whatever discipline may have been imposed there. If somebody's, disrespectful to their superior and they still get a suspension, frankly, that's probably whatever discipline happens at that level is probably just fine. So by definition, we need to focus on certain cases that may warrant a discipline that the agency is not able to impart, for example, or where we feel it's insufficient, or where we feel it needs to be a decertification, which is a resource intensive. Even though there's very few cases, it's resource intensive. We have lawyers in our division of standards, and there's a lot of documentation that goes back and forth for these hearings, as you may very well know. They get admitted into the record or not, et cetera. So we need to prioritize, and we do.
I think we ask those questions because we do hear a lot of cases. And some are, some we don't get. Some are managerial suspensions or corrections. And there's some that then cross that line, and we hear those. Those are more critical cases that we tend to hear. So
yeah. So we still should collect them to be part of the records, of the disciplinary records, again, we may decide to do nothing with them other than make sure that the internal affairs investigation is closed and the discipline is reflected in the record, and now it goes in the database. But we get, I'll go in front of chiefs or other groups. They have questions about these minor matters quite a bit. And we've issued guidance. Again, we're not interested in discourtesy, even though we believe all officers should be courteous in interacting with the public. We understand sometimes lose their temper. They do a number of things, and we're just not going to look at things like that. To be candid. Now, where there's trends, when there's racial profiling, absolutely. Where there's bias, absolutely. I don't want to minimize anything that I'm saying. So there's a lot of case by case. It's really the bottom line.
yeah, I think before we had cameras, we had more cases than we had now. I think our cameras have helped us because now they're aware that they're being recorded as well. So all that bias, all that thought mindset would have to be reframed and done differently. So you're right, it's a lot less cases, and those that are going corrupted, we'll get to see those, right? So.
Well, thank you for having us. Yeah. Yep.
Have a safe trip back now.
All right, well,
Good job.
That was helpful. I learned a little bit about what they're doing and how they're doing it. It's pretty good, the investigators or judges.
I used to be a traffic reporter, I can't even get along.
The heck out of it.
Nice to see you both, thank you so much.
We're actually doing the same job. We're getting recorded.
We could, you
Got
know,
a political friend?
the JC did say that we could.
I read that
That's up to
several
the-
There's
times.
always
Yeah, I
that
know.
way,
It's up to the-
Doc.
City council and mayor.
I showed a couple. All right, how do I pick up, where's my attorneys? Okay, well, we can jump right in. Yeah.
The mic's on?
Is the mic's on? Can we go to new business? Or do I have to say anything going into that? All right, under new business.
Kara does all the stuff.
We gotta wait for Devin.
Her and our office manager, Brianna.
Yeah, so I can find out. Wow, it really is getting it. Devin, we have discussion, we're on to the new business. Discussion of upcoming training, and that was, everybody received something, they want to start in December with the training from IIU?
No,
November.
Next Wednesday,
That's
we have
right.
the IIU training
Okay,
at 4:30 here.
right. And then we have more training they asked us about for December, starting in December, one a month.
Yeah, so that's through the academy. So they're developing training that's going to be administered every month for 6 months, starting in December.
And anything that goes on in the academy training that starts in November, we will be invited to. If you have the time during the day or whatever and you want to go that day, we can go to that too. They'll invite us, they'll tell us the dates. So if anybody's available, you can go to that. Just wanted to pass that along, I saw that. And then we got manual interpretation. Dr. Birdie, I think you put that in.
In our future trainings, when appropriate, I'd like to know better, at least from a practice point of view, rather than what should be or what is in the manual. What is the actual practice by which board members are notified of complaints that are handled, investigated, and disposed of by the superintendent?
So that should be included in the biweekly report, which lists all complaints, the status of their investigation, and the outcome.
Yeah, and you guys get them faithfully every 2 weeks. I just sent the last one out, I think.
Yes, thank you. Yes, we do, but I think what he's asking for is what happens after. Was it completed, was it, you know?
Well,
what's
it's
the follow-up?
it's in the bi-weekly report, so if there's a case that's gone to it's been recommended for the superintendent, once he comes up with some sort of discipline or disposition on the whole thing, it's included in that. So that particular case that's now under superintendent review will now change to status, and it'll say unfounded, or it'll say sustained, 5-day suspension. That's been in every single report.
So we see that?
Yes, it's in the reports. Yes.
it up underneath it or something.
Oh, okay. I didn't see that.
Well, can we get clarification on that? Because when it says under review, under investigation,
When it's under investigation, it means it's in its investigation phase. So either we're investigating, or it's a PI and it's being investigated at the squad, or you know, whatever division the officer belongs in.
Is it
When it's
clear?
under review, it means either it'll say superintendent review. If it's one of our cases, it'll go
Right.
to the superintendent,
Well,
or
I
it's
think
board
what
review.
I'm asking for is, so what's the disposition?
It says that if there's a case that's been disposed of, it'll say unfounded, or it'll say sustained 5-day suspension.
Okay, I somehow missed that.
Yeah, it's on every single case that's come back.
I just looked at the most
It's
recent
not.
one.
It's not,
What's not?
because the last one and this one, I didn't see it.
Oh, it just, a lot of them say under investigation,
That's
and
it.
one says unfounded.
And that's it.
That was a case that
Yeah.
came back. If it says unfounded, it's because it's come back.
But the other ones are still in investigation.
You're
right?
still under investigation or review, yes.
Yeah, and we'll get the responses later on,
The next one.
on the
you
next
get,
one,
yeah.
okay.
Okay. Is there anybody else on? Okay, and I'll ask again, any lethal use of force, even if somebody isn't killed, I don't know, definite term, we are notified about now, any shooting or anything,
Right,
right?
yeah, I think we've talked about that before, so like,
Yeah,
you guys, said that we were gonna notify you if that happens.
Okay.
So, and I think you had mentioned that, you know, it doesn't have to be immediate because.
No, just so we know,
Within
because,
24 hours, 48 hours, you guys will know.
because he just
If it
mentioned,
happens on the weekend, I don't.
yeah, well, he mentioned that post, that they're notified anytime a weapon's used.
Right.
And I know of a case where a weapon was used, and we never were notified, we never were involved, and a person was wounded in that incident. It's obviously still a burr under my saddle, because I just don't understand how we couldn't have been notified, but, okay, that's why I'm sorry to
We should
keep
change-
asking,
So
but,
we should change it then to be more clear. We wanna know in 12 hours, so that way we know, because sometimes they forget.
So you wanna be notified on the weekend in 12 hours?
That's okay.
So I'll have to let the superintendent let you know.
ask him if he could, yeah, if there's a text system, we could do it. No, that's why I'm asking him if he could do a text system for us.
As a board, we could
Yeah.
recommend, so that's what we're.
And if we want us to tell him, we can do whatever you'd like. Does that make sense? Just so, because that one, I'll stop. Time to move on. That's where the board notification of lethal force, that's why that one bothers me. The use of force committee was brought up. Does that?
Mine, again, I'd just like to know, maybe the use of force committee could act as that conveyor of information that we want to know more about. Maybe, I'm just wondering, when was the last time the board had a member sit on the use of force committee meeting?
That's, as far as I know, that's still in limbo.
Yes,
There's
I'm actually
an-
not that committee, and I haven't received anything, and
So there's an agreement between the city, Department of Justice, and the compliance evaluator team to keep that on hold. In the short term, I think they're just working out a resolution about how that's gonna work.
So I'm confused, so they're working it, but we're not involved with it? We're not like in the midst of it to learn what's happening?
So there's
Because
one-
last time I was in the mix of it, we had one board member to show up even though.
Me.
Yeah, exactly, even though they were just starting to review and get it done, not exclude us from it until it was done.
There's been nothing done, as far as I know.
So no meetings at all?
No.
Okay.
And yes, that is part of the settlement agreement, that one member of the
Correct.
police commissioners will be part of that board.
Right, thank you.
Is there any old business? Okay, I would, Oh.
Mr. Chair, did we ever do B, manual interpretation? I may have missed that.
yeah, I thought it was said that.
Yeah,
Do it in the training.
It was asked about manual interpretation and turned into disposition of complaints. So is there a question about the manual?
I'm just wondering, is there any cross-reference between like the IIU manual and our manual when it comes to certain things?
What do you mean by cross-reference?
Let me think for just a moment. We'll say the notification, you know, the use of force, the use of officer-involved shooting. We may have it in our manual that says we would like that notification within 12 hours or 15 or 30, but what if it's not codified in another place, like maybe the IIU manual?
I don't think our manuals mentions that. I came up with the whole PowerPoint, and I don't remember that being in there at all.
Okay.
Maybe it's
Maybe
in
for
your
future
manual.
discussion?
I can't remember. I haven't read it in a while.
Because I think it's fairly obvious we're sensitive as representatives of the community about any time an officer uses deadly force. Justifiably, it's still important that we know.
I mean, some of us get called immediately, so, I mean, depending what neighborhood it is, right? So
Right.
probably more than me than you guys, right?
But
So I get called like that,
Yes,
so
it does. You're 100%.
I don't wanna not be aware.
Thank you, sorry, I missed that.
All right, so if we're all done with old business, I'd entertain a motion to adjourn.
So moved.
make a motion to adjourn.
This is a motion to adjourn at 5:44 PM.
I make a motion to adjourn.
Yep.
Oh, I'm sorry,
He said,
Company or?
I think
Commissioner?
C moved it, so.
I made a motion, C second.
Yep, I got the second. Roll call, Commissioner Fernandez?
Yes.
Commissioner Jackson,
Yes.
Commissioner Birdie,
Yes.
Commissioner Roldan,
Yes.
Commissioner Trangizi.
Yes.